Hi everyone. Good morning. Good morning. This is Ifama Odunlami, immigration attorney from the Odunlami law firm. I'm gonna wait a little for people to come in, but for those who don't know me, my office is in New Jersey, but we represent clients in all 50 states of the United States and abroad. And today I have some good news, breaking news actually, and it's good news for intending immigrants. So I want to talk about that a little. This information came from a lawsuit that was filed and has now led to the USCIS changing its interpretation of the law, right? So, you guys, if you know somebody who wants to partake in this conversation, let them know now so that we can talk about this. Remember, I said that our purpose is to make sure that we are immigrants who are aggressive about knowing what's going on, so that we don't fail to get information that may help us in our situation. So, like I said before, the reason I do this videos is to make sure that my fellow immigrants know what's going on, know when they can get into something that may help them. So if you're somebody who maybe has gone to an attorney before and the attorney told you that the law doesn't work in your favor, right? Well, guess what? There's a new interpretation of the law. The law is still the same. It's just that USCIS has changed its interpretation, and I'm going to go into it in a minute. But I just want you guys to know how important it is for you to stay tuned on the changes that's going on in the law, because it may benefit you. You do not want to lose out on the chance of getting a green card because you're not aware of how the law changed since the last time you spoke to an attorney, or since the last time you had some kind of contact with USCIS. So let me get into this now. Hi, everyone. So if you're on, say hello. So I know I'm not speaking to myself. So this law came about as a result of a lawsuit that was filed, Gomez versus USCIS. And basically, the lawsuit has led USCIS to change the way it reviews certain cases. So what it is that in the past, right, if you came in and you overstayed, you accrued what they call unlawful presence, right? And unlawful presence is, you come in with a visa and you stay longer than you're supposed to stay, right? And you're out of status. Now you accrue, or you come in through the border, you accrue a 3-year ban or a 10-year ban, depending on how much unlawful presence you accrued, right? So in the past, if you got somebody who was going to file a paperwork for you, and you were still here, you would have to file a waiver of forgiveness for the unlawful presence you have accrued before you would be allowed to adjust your to get your green card. And that waiver requires you to leave the country. So you get the waiver for unlawful presence. You're forgiven for having stayed longer than you should have, and then you have to leave the country and continue your work, your case through consular processing. So basically, the 3 or the 10-year ban are inadmissibility bans, which means that you're not allowed to come back to the country or adjust your status or get your green card until you've gotten a waiver of a sort. So this new law basically applies to only people who, the scenario is, you came in, you overstayed, and you left, and you triggered the 3 or the 10-year ban, but somehow you were able to get another visa to come back in, right? Lawfully this time, right? And so you have somebody who's willing to, who's applying for a green card for you, and you cannot adjust your status because of that period of, because of the unlawful presence. Now, with the new interpretation, USCIS says that you can stay in the United States and live out your period of inadmissibility and then adjust your status without having to go back to your country or without having to get a waiver. So although this does not apply to everybody, it's huge for those that it would apply to, because it really makes a difference. So basically, let me talk about the people it does not apply to, right? If you have a permanent bar, it does not apply to you. So let me explain what a permanent bar is. So a permanent bar is applies to an alien who has been unlawfully present in the United States for more than 1 year, and then you leave and you come back before before the 10-year or 3-year period is up, right? That's on a permanent ban. Actually, if you've been here for more than 1 year, it's a 10-year ban, and you leave and you come back without papers. You come back again illegally without or waiting for that period of inadmissibility. So that's a permanent ban. A permanent ban is also applies to people who have been ordered deported and they come back again illegally without, getting proper paperwork done to waive in any period of inadmissibility or, a permission to come back before the 10-year period is up. So those are the people who are subject to the permanent ban. This does not apply to them. Now, the permanent ban, even though it says permanent, there's some exceptions. You know the law, there's law and there's some exceptions. The permanent bar, an exception to a permanent bar is somebody like a VAWA applicant who can show that the reason the second illegal entry was related to the abuse. So VAWA self-petitioners can, they can waive the permanent bar, but not everybody can. So so basically, reading from the text from USCIS, the USCIS now says it intends to modify its interpretation of 9B to no longer require an applicant for adjustment to spend his or her period of inadmissibility outside of the United States. And USCIS is now in the process of finalizing a revised policy, including final approval by the Department of Homeland Security and issuing new guidance to USCIS adjudicators. And USCIS says that right now it's not currently denying adjustment of status applications or requiring applicants to file waiver applications on the basis that an applicant returned to the United States within the period of inadmissibility under this section. So basically, if you're here already and you're one of those who had left accrued unlawful presence and come back with a legal visa, right? They're not going to deny you right now, even though they haven't, put out they haven't given us the proper guidelines, but they're not denying those cases. So you want to know that. Let's see. And another group of people that this does not apply to are those who came here, overstayed their visa, and are still here. Unfortunately, that does not apply to you. You can still not adjust your status unless you're married to an immediate relative, a U.S. citizen spouse, or you're the parent of a U.S. citizen who's over 21, or you have a child who's under 21 and you're a U.S. citizen. So those three categories, it would not matter if you've overstayed your visa. All right. All right, guys. Let me say hello to everyone on the chat. Hi, Adebayo, Adekunle Daniels. How are you? Nice. Thank you for coming in. And Kenny, thank you. Kenny, you say you have a question for a friend of yours. Okay, what's the question? Shoot, because I have just about a couple minutes more. All right, because I'm here to answer the questions, or you can, if I leave, you can put the question on the chat. When I come on live again, I will answer the question. Okay. So Kenny, if you want to, reach out to me later, that's fine, and ask the question for your friends. So you guys, so this is great news. And the reason this, even though this does not apply to you, but it should give you hope, because it means that this administration is changing certain policies, for a kinder, gentler USCIS, and we always like that. So you guys, I'm going to sign out. Hi, Bukola. Thank you very much for signing in. Again, you know how to reach me, 973-993-1900. And I'm always happy to help fellow immigrants because I'm an immigrant just like you. My husband is an immigrant just like you, my siblings, my mom. So we've had our own journey, and my passion is to help other people make that journey successfully and with as little stress as possible. So take care, guys. Have a great week.